Hi guys, welcome to another episode of A 30 Vlogger, Law for the Everyday Layman. Today we continue with our discussion on the Securities Regulation Code, and specifically today, we'll talk about the prohibition on fraud, manipulation of security prices, prohibition on insider trading, the requirement of registration of market professionals, and registration of exchanges. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now, a like on this video or any of my other videos would also be greatly appreciated. Now, we can begin with our subject matter. As I mentioned in the previous episode, one of the main purposes of the SRC is to protect investors. And I already discussed one of the means to do that, which is the requirement of registration of securities. And today, we continue with the other ways by which the SRC, the Securities Regulation Code, protects investors. And we'll begin with the prohibition against manipulation of security prices, meaning simply that you should not manipulate the prices of securities, no? And this is intended to protect the investing public. Section 24.2 explicitly states that no person shall use or employ in connection with the purchase or sale of any security any manipulative or deceptive device or contrivance, which is contained in Section 24, no? Which states that it shall be unlawful for any person acting for himself or through a dealer or broker directly or indirectly to, and it lists the prohibited acts, no? First, to create a false or misleading appearance of active trading in any listed security traded in an exchange or any other trading market. Okay? You're creating a false or misleading appearance of active trading. Okay? How? By effecting any transaction in such security which involves no change in the beneficial ownership thereof. Okay? Second, by entering into an order or orders for the purchase or sale of such security with the knowledge that a simultaneous order or orders of substantially the same size, time, and price for the sale or purchase of any such security has or will be entered by or for the same or different parties. Or third, by performing similar acts where there is no change in beneficial ownership. Okay? So it's just a transfer, but there's really no change in the ownership. You're creating a false or misleading appearance of active trading when in fact there is no trading going on. So that you will create in the mind of the investor that, hey, this stock looks like it's going to go up, let's invest in it. Okay, that is prohibited. Another prohibited act would be to effect alone or with others a series of transactions in securities that raises the price to induce the purchase of a security, whether of the same or a different class of the same issuer, or of a controlled, or commonly controlled company by others. Second, it can also depress the price or lower the price to induce the sale of a security, whether of the same or a different class of the same issuer, or a controlling or controlled entity. Okay? Or it may also create active trading to induce such a purchase or sale through manipulative devices such as marking the close, painting the tape, squeezing the float, hype and dump, boiler room operations, and other similar devices. I'll explain each of those later, okay? Third, okay, to circulate or disseminate information that the price of any security listed in an exchange will or is likely to rise or fall because of manipulative market operations of any one or more persons conducted for the purpose of raising or depressing the price of the security for the purpose of inducing the purpose of sale of such security. Fourth, to make false or misleading statements with respect to any material fact which he knew or had reasonable ground to believe was so false or misleading for the purpose of inducing the purchase or sale of any security listed or traded in an exchange. And fifth, to effect either alone or with others any series of transactions for the purchase and or sale of any security traded in an exchange for the purpose of pegging, fixing, or stabilizing the price of such security unless otherwise allowed by the SRC or by the rules of the SEC. Okay? So here, what is prohibited is the creation of the active trading or raising the price when such is not the fact, no, to induce transactions, no, purchase, sale of securities, no, and this prohibition is to protect the investing public. Now, the SRC also prohibits short sales, which are sales where the seller does not own the security which he is selling, or when the sale is consummated by the delivery of a security borrowed by or for the account of the seller, or where the seller purchased the shares later, either to offset what has been earlier sold or to return the shares purchased to the lender. Now, the only time short sales will be allowed is if they are done in accordance with the rules and regulations of the SEC. Another thing that is prohibited would be stop-loss orders, which are orders placed with a broker to buy or sell a specific stock once the stock reaches a certain price. It is designed to limit an investor's loss on a security position, and they are prohibited unless done in accordance with the rules prescribed by the SEC. Okay? So the foregoing acts are prohibited by the SRC because they tend to manipulate the prices of securities to the prejudice of the investing public. And the IRR, the implementing rules and regulations of the SRC, give examples of the prohibited conduct, no, which I mentioned earlier. First, painting the tape. Painting the tape is engaging in a series of transactions in securities that are reported publicly to give the impression of activity or price movement in the security. Okay? It's called painting the tape because if you go by Makati, no, and you will see there the prices of the exchange of the securities are being reflected in the banner that scrolls by. Before, those were indicated in an actual tape, and they would be painted either red or blue, no? And that would be manipulative if it is not the case, no? You're just creating the impression of activity, and that is prohibited because you are manipulating the price to induce investors to invest. Okay? So that's a prohibited practice. The investor should invest because of what is the actual situation, and not because you are creating manipulative schemes to induce him to buy. Okay? Another example would be marking the close, which is buying and selling securities at the close of the market in an effort to alter the closing price of the security. Another one would be improper matched orders, which is engaging in transactions where both the buy and sell orders are entered at the same time with the same price and quantity by different but colluding parties. Another one is hype and dump, okay, which is engaging in buying activity at increasingly higher prices and then selling the securities in the market at higher prices, or vice versa, selling activity at lower prices and then buying at lower prices. Okay? We also have wash sales, which would be engaging in transactions in which there is no genuine change in actual ownership of a security. Another one would be squeezing the float, which is taking advantage of the shortage of securities in the market by controlling the demand side and exploiting market congestion during such shortages in a way as to create artificial prices. Another prohibited act, example of a prohibited act, would be boiler room sales, which is the use of high-pressure sales tactics by an organized operation of salesmen to promote purchases and sales of securities. Okay, there's an old movie, no, Boiler Room, and also you can check out Wolf of Wall Street, no, like that. Another example of a prohibited act would be the daisy chain, okay, which is a series of purchases and sales of the same issue at successively higher or lower prices by the same group of people with the purpose of manipulating prices and drawing unsuspecting investors into the market, leaving them defrauded of their money or securities. And one last would be disseminating false or misleading information through media or other means in order to move the price of a security in a direction that is favorable to a position held or a transaction. Okay, and there are others. These are just examples. Take note, however, that the SEC may allow some of the prohibited acts by imposing certain rules and regulations if it is in the public interest and for the protection of investors. If manipulation can be shown to have attended the sale, then the sale will be voidable. Okay, it's valid until annulled. It will be voidable at the option of the buyer without prejudice to any liability for violation of the SRC against the party who caused the manipulation. Now, in Section 25, the SRC prohibits any member of an exchange from directly or indirectly endorsing or guaranteeing the performance of any put, call, straddle, option, or privilege in relation to any security registered on a securities exchange. When we say put, that is an option that, in consideration of a premium paid, gives the purchaser the right to make the seller take from him a given number of shares of a named stock between a given time at a stipulated price, which is usually below the prevailing market price of the stock at the time the put is purchased. When we say call, that is an option which, in consideration of a premium paid, entitles the buyer to compel the seller to deliver to him a certain number of shares within a given time at a stipulated price, which is usually higher than the prevailing market price at the time the call is bought. It's the reverse of put. Okay? Put and call are opposites, no? And we also have straddle, which is the double privilege of a put and a call, and secures to the holder the right to demand of the seller at a certain price within a certain time a certain number of shares of a specified stock, or to require him to take at the price within the same time the same shares of stock. The SRC in Section 26 also prohibits fraudulent transactions when it states that it shall be unlawful for any person directly or indirectly in connection with the sale or purchase of any securities to, first, employ any device, scheme, or artifice to defraud. Second, to obtain money or property by means of any untrue statement of a material fact or any omission to state a material fact necessary in order to make the statements made in the light of the circumstances on which they were made not misleading. Okay? So if there's a material fact, it should be stated, or there should be no omission to make that material fact. Okay? Third, to engage in any act, transaction, practice, or course of business which operates or would operate as fraud or deceit upon any person. Fourth, a broker, dealer, salesman, or associated person shall not make use of information they have obtained in a fiduciary capacity for the purpose of soliciting or making purchases, sales, or exchanges of securities, nor shall they provide such information to any person who does not need such information to fulfill their duties under the law. And fifth, misrepresentation is also punished, such as misrepresenting that the broker-dealer is registered, that a security of a particular type is registered when it is not, or that security has been sold, mortgaged, or otherwise transferred when in fact it has not been transferred, or to sell or deal in securities when the seller is not actually registered. Okay? So, in general, fraud is prohibited, and there is a corresponding liability, therefore, under the SRC. Now, let's move on to insider trading. Another way that the SRC protects investors is by prohibiting insider trading. So, take note that being an insider in itself, is not prohibited. Okay? You can be an insider. What is punished is insider trading. Again, being an insider in itself is not prohibited. And an insider means either the issuer itself, a director, officer, or a person controlled by, or under common control with the issuer, or it can also be a person whose relationship or former relationship to the issuer gives or gave him access to a fact of special significance that is not generally available about the issuer or the security. It can also be a government employee or director or officer of an exchange, clearing agency, or a self-regulatory organization who has access to material information about an issuer or a security that is not generally available to the public. Or it can also mean a person who learns of such fact from any of the foregoing insiders with knowledge that the person from whom he learns that fact is an insider. Okay, take note, this is usually where the trick questions come in exams, okay? So under this item, even a janitor or some stranger passing by on the street can be considered an insider if they overhear material non-public information and they know that the person uttering such information is an insider, okay? Now, what is unlawful, again, is for an insider to sell or buy a security of the issuer while in possession of material information with respect to the issuer or the security that is not generally available to the public. Okay? That's the long version for what is prohibited is insider trading. It's okay to be an insider. It's not okay to perform insider trading. So, again, what is unlawful is for an insider to sell or buy a security of the issuer while in possession of material information with respect to the issuer or the security that is not generally available to the public. And the law defines what material non-public information is. It is information that has not been generally disclosed to the public and would likely affect the market price of the security after being disseminated to the public, and the lapse of a reasonable time for the market to absorb the information. So if it has been published in the newspaper, then it is already public. Okay? So it's all right to that information is already safe. Okay? Information is also material if it would be considered by a reasonable person as important under the circumstances in determining his course of action, whether to buy, sell or to hold a security. So in this regard, the law also makes it unlawful for any insider to communicate material non-public information about the issuer or the security to any person who, by virtue of the communication, now becomes an insider. Okay? So he's not supposed to communicate information because that will make the person to whom it is communicated to, it will make him an insider. Okay? Where the insider communicating the information knows or has reason to believe that such person will likely buy or sell a security of the issuer while in possession of such information. Now, the law also creates a presumption of insider trading when it says that a purchase or sale of a security of the issuer made by an insider or such insider's spouse or relatives by affinity or consanguinity within the second degree, legitimate or common law, shall be presumed to have been effected while in possession of material non-public information if transacted after such information came into existence but prior to the dissemination of such information to the public and the lapse of a reasonable time for the market to absorb such information. This presumption may be rebutted, okay? It may be overcome upon a showing by the purchaser or the seller that he was aware of the material non-public information at the time of the purchase or of the sale. So, the law allows for exceptions to the unlawful acts. In other words, the sale of a security while in possession of material non-public information will not be unlawful. In other words, it will be legal if, first, the insider proves that the information was not gained from such relationship, or second, if the other party selling to or buying from the insider or his agent is identified, then the insider proves that he either disclosed the information to the other party or that he had reason to believe that the other party is also in possession of the information. In punishing insider trading, the intent of the law is the protection of investors against fraud, which is committed by an insider who uses secret information. He takes advantage of the uninformed investor. Now, investors are obligated to disclose material information to the other party or abstain from trading the shares of the corporations. This duty to disclose or abstain is based on two factors. First, the existence of a relationship giving access directly or indirectly to information intended to be available only for a corporate purpose and not for the personal benefit of anyone. And second, the inherent unfairness, inherent unfairness involved when a party takes advantage of such information, knowing that it is unavailable to those with whom he is dealing. So the gravamen of the offense is the insider's misuse of the non-public and undisclosed information. The law also punishes insider trading in relation to tender offers, and I'll discuss tender offers in the next episode, okay? But for now, I will say that the law punishes two acts. If any person other than the tender offerer is in possession of material non-public information relating to the tender offer to buy or sell the securities of the issuer, if that person knows or has reason to believe that the information is non-public and has been acquired directly or indirectly from the tender offerer. Okay? I will discuss this again when I talk about tender offers. But the second is any tender offerer, those acting on his behalf, the issuer of the securities sought or to be sought by such tender offer, and any insider of such issuer they communicate material non-public information relating to the tender offer to any person where such communication is likely to result in insider trading involving such tender offers. Okay? So to sum up insider trading, you just know a special a fact of special significance. Okay? And that makes you an insider. If you communicate that information and to a person who will purchase the stock relying on that information, that's insider trading. Okay? So, you do not want to, the law prevents the misuse of information such as, which is not available to the public because it prejudices the investing public. Now, let's move on to the requirement of registration. Another measure of protection for the investing public under the SRC is the registration of brokers, dealers, salesmen, associated persons, and stock exchanges. The SRC says that any person who wishes to engage in the business of buying or selling securities in the Philippines as a broker, dealer, or to act as a salesman or an associated person of any broker-dealer must register with the SEC. There are certain requirements for registration, including a written examination in the case of natural persons. Because of course, a juridical entity cannot take an exam, no? And in case of entities, there's the requirement of unimpaired paid-up capital, okay? The values may differ, especially in the years that may come, no? When the currency fluctuates. But as far as I know, there is the requirement for 100 million, 30 million, or 2.5 million, depending on the transactions that the entity will engage in. Now, a broker-dealer, okay? I'm not committing a mistake. It's really broker-dealer. A broker-dealer under the implementing rules is an entity that buys or sells securities for its own and customer's account. And when it is registered, then it will have a perpetual license, meaning it is valid until otherwise revoked for cause or suspended or voluntarily surrendered. And of course, there must be payment of an annual fee every November. Salesmen and other associated persons are, of course, natural persons. The broker-dealer is a juridical entity, and the salesmen are natural persons. And of course, the salesmen must also be registered. The salesman, of course, he buys and sells securities on a salary or commission basis, while the associated person is a full-time employee of the broker-dealer, whose responsibilities include internal control, supervision of other employees, salesmen, directors, etc. of the broker-dealer. They cannot perform other duties without the approval of the SEC. Now, the rules of the SEC list the qualifications and duties of these people, and when registered, they will also have a perpetual license, subject, of course, to the payment of an annual fee. Now, the SEC may exempt any broker-dealer, salesman, or associated person from registration as long as it is consistent with the public interest and for the protection of investors. And of course, they are bound by the ethical standards rule, meaning that they shall observe high standards of commercial honor and just and equitable principles of trade. The IRR lists certain standards such as honesty, fairness, diligence, avoidance of conflicts of interest, and etc. Okay? It's just a code of conduct. And they are bound to observe the suitability rule, which states that in recommending to a customer the purchase, sale, or exchange of any security, a broker-dealer or salesman or associated person shall have reasonable grounds for believing that the recommendation is suitable for such customer upon the basis of the facts disclosed by such customer as to his other security holdings and as to his financial situation and needs. Now, the IRR prohibits these individuals from publishing any notice, news article, communication of any kind that purports to report any transaction as a purchase or sale of any security, or to quote the bid or ask price for any security unless he believes that such transaction was a bona fide purchase or sale of such security, or that such quotation represents a bona fide bid or offer for such security. They should also not give or offer to give anything of value to any person for the purpose of influencing or rewarding that person in connection with publication of any matter which has or is intended to have an effect on the market price of any security, unless it is clearly identifiable as paid advertising. They should also use reasonable diligence to ascertain the best market for the subject security and buy and sell in such market, so the result to the customer is as favorable as possible under the prevailing market conditions. Now, exchanges, transfer agents, and clearing and settlement must also be registered unless they are otherwise exempt. We only have one exchange, and that is the Philippine Stock Exchange, which is in the Fort, BGC rather, which is currently a shareholder-based revenue-earning corporation headed by a president and a board of directors. Okay? I apologize, the sunlight is hitting me. I don't usually record at this time, Now, we move on to the last topic today, the independent directors. Okay? As another measure of protection to the investing public, the requirement of independent directors is provided for in the SRC. And similar to the Revised Corporation Code and the Code of Corporate Governance, the SRC emphasizes the need for an independent director. Okay? And an independent director is a person who is independent of management and free from any business or other relationship which could reasonably be perceived to materially interfere with his exercise of independent judgment in carrying out his responsibilities as a director in any of the covered companies under the Code of Corporate Governance. The implementing rules, it lists the qualities of an independent director under Rule 38.2. And as for the qualifications and disqualifications, that's in Rule 38.6. Namely that he must have at least one share of stock of the corporation, he must be at least a college graduate, or has been engaged or exposed in the business of the corporation for at least 5 years. He must possess integrity or probity, and he must be assiduous, meaning that he shows great care or perseverance. Now, this independent director should not be an officer nor an employee of the corporation where he is an independent director, and his beneficial security ownership should not exceed 2% of the outstanding capital stock. Also, he should not fail without justifiable cause to attend more than 50% of the total board meetings during his incumbency. Okay, if he fails in all those, then he will be disqualified. Other disqualifications may also be provided by the corporation, okay, under the Code of Corporate Governance. Okay, now the purpose of having independent directors is to ensure that no director or small group of directors can dominate the decision-making process, and also to assure protection of the company's interests over the interests of individual shareholders. Now, while all companies are encouraged to have independent directors, issuers of registered securities and public companies are required to have at least 2 independent directors, or at least 20% of its board size, whichever is less. But of course, they can have more if they want, no? But when it comes to exchanges, they are required to have at least 3 independent directors. Now, in case of resignation, disqualification, or cessation of independent directorship, if there is a vacancy, that vacancy will be filled by a vote of at least a majority of the remaining directors if still constituting a quorum, after notice to the SEC and within 5 days from occurrence of the vacancy. Okay? So that's it for my discussion today. No? And I hope you may have picked up a thing or two. Again, I apologize for the sunlight. I don't usually record at this time. Okay? So I hope to see you next time, guys. See you soon. Bye.